You know, I thought I would have stopped making videos, but this thing is bothering me because I cannot see how the legal mind of the EPA is not seeing this thing. I can't understand why they are saying that we have to wait until the chairman resign in order to go forward with this, when they have a lawyer that knows his thing and they are letting this pass. So let me show you what I'm speaking about. So this is the verbatim notes here I'm going to read from. The verbatim notes is the exact thing that went on this date here. This is our case when we went in. So I want to show you some things that the chairman said, you know, while on the journey. Simple things. Nice. So this is his saying here. I feel that the bank ought to be penalized in some way for trying something and things, you know. I don't know what to say here. But the word I want to show you here is penalized. So he say he thinks the bank should be penalized, right? So this is what I want to zero in here. Alright, the chairman. So after the arguments and whatnot, he said, I would suggest that Mr. Simmons and the bank meet with the EPA. I suggest you meet with them and see if you can come up with something. Come up with something. I mean, come up with something. I don't know that would allow the matter to be settled rather than have to come back here and deal with the whole question of retrenchment and redundancy and the method of calculation of the severance. Alright? And having said that, I'm not saying that the EPA ought to go there and try to extract anything. When you look at the payments the people got, they were good payments. So he's not saying to go to extract any money. Alright? Because we talk about payment here. He said it was good payment. So this what he said here, go to the bank. Alright? Is not really talking about looking for any money. This is clear because you see when you look at the payments people got, they were good payments. Alright, so go back to the bank for what? Why did he suggest to go back to the bank? Alright, how would the bank be penalized? Okay, alright, so he said that you know, go and talk, maybe reinstate the officers, then you have to come back here to talk about retrenchment and redundancy and the method of calculation for severance and so on. Alright, so I want you to just look at this and remember this statement was made in the first hearing that we have. Alright, so here we look at here. Alright, so we come here. Now this is the judicial review here, where the lawyer had to put in the evidence of the case. So he's going before the court for judicial review of what went on when the special tribunal dismissed the case. Alright, so this is in the appeal court, right? So you have to give the evidence of what happened in the industrial court. All right. Let me read from down here. All right. So at the same, these were the applications that were put in the industrial court by these people. So he is doing his giving his evidence and an application. The application is evidence and argument content that the dismissal, as grounds of redundancy, and he's saying that this is what these evidence were given in the industrial court, right? That's what he's saying here. All right. He's also saying that there was no contention in the evidence and argument. All right. So there were no contention in the first hearing. None. No contention. All right. So that means the court was there to hear the arguments and everything here. Here is the important thing I want you to realize here. You see, I am informed by Mr. Thompson. So Mr. Thompson is the one that was giving him evidence of what went on in the court. An industrial relation consultant who represented the applicants before the special tribunal and well believed seemed to be true. He believed that everything that Thompson told him that it was true, that the hearing of a dispute of a special tribunal was conducted. All right. Was conducted on the 15th of March 2027 and the 31st of January 2028. So he's saying that it was conducted on 2 days, right? That on those days, 2 days, on the 2 days, the tribunal heard evidence of the application, Mr. Robert Ramota, and on the 31st. Now, he's saying on these 2 days he hear evidence, but on this day, the special tribunal held that it had no jurisdiction to hear and determine the dispute. All right? It was heard 2 days. All right? Evidence. So it is saying that evidence was heard in 2 days. Right? But on the second day, all right, the special tribunal dismissed the matter. All right? So here now, I want you to come back here. Remember, he left out this. Alright, those 2 days, he gave an order to go back to the bank. Alright, this is missing. Alright, it says again, alright, on those 2 days. Alright. Yes. He said, I am informed by Mr. Thompson and verily believe same to be true. When the special tribunal dismissed the dispute on the 31st, he had no prior notice that the special tribunal intention to dismiss the dispute on the basis that it did not have jurisdiction to hear and determine. And in fact, it was RBC Limited case special did not have jurisdiction to hear the dispute, that the special tribunal, it provided no reasons for its decision. Remember, it provided no reason. It's not anything about redundancy. Remember, it have nothing about redundancy, because what redundant, not redundancy, it was not about branch board, sorry. It was not about branch board. It had no reason. So branch board was not an issue for him dismissing the case. Alright? So realize that this is the evidence. Okay, that this is the evidence that Thompson gave. It have no verbatim notes here. Realize? Alright? A true copy of the order. That order would be when he dismissed the case. I wonder if it's below the order. Alright. A true order. That order would be when he dismissed the case. Boom, boom, boom. Where is it here? Alright, it's not here. Alright, so that order will be when he dismissed the case. Alright, so let me come back here now. Here, and show you now the facts. Alright, so in this same affidavit now, right now, the court, the lawyer got evidence from Mr. Thompson. Right, he did not get a verbatim note. This is why he did not get a verbatim note. I'm the attorney of Chancery Lane, bam bam bam. The fact of the matter disposed herein is true and correct, and within my own personal knowledge, save and stated to be on information and belief, in which case I verily believe the same is to be true. Alright, the affidavits and supplemental to my affidavit sworn to and filed on the 30th of April, hereinto referred to as my principal affidavit. Alright, so he's saying the principal evidence of the parties and replies and statements and the documents and exhibits. This is what he put in. Okay, you see, and a copy from Bullock, right, register. Nice. So this is what he put into evidence. All right. To that affidavit, a copy of a letter dated the 18th April 18, 2018, from Mr. Bullock, attorney at law, to the registrar of the industrial court, requesting that he be provided with the copies of the evidence of argument, replies, and witness statement filed by the parties. All right. So he applied for those information. I have been informed by Mr. Bullock and believed to be true that the date and the transcript verbatim notes have not been provided, and that in fact another letter, so from here to here, another letter was sent by Mr. Bullock, registrar, requesting a verbatim notes transcript, a true copy of the said letter. So instead of verbatim notes into evidence, they put letter that they did not get it. Another one, all right, a phone registrar of the court spoke to Mr. Pamela Lochman, clerk of the registrar, all right, and the registrar could not say when they would be made available due to the shortage of staff who perform transcribing duties at the industrial court. I again followed up on the 8th of May by contacting the registrar of the court. So this is the evidence to show that they never received the verbatim notes in the appeal for the judicial review. Okay. So I provided my information, all right, and to get some answers. So this is all my research on the internet, right? So potential grounds for removal or recusal based on the information that I now provided, and this is the answers that I got. All right, based on the information provided, there might be potential grounds to challenge the chairman's conduct. Failure to provide verbatim notes. Procedural impropriety. The refusal to provide verbatim notes could be seen as a procedural irregularity, potentially affecting the fairness of the proceedings, natural justice. The inability to access verbatim notes might hinder a party's ability to present their case ineffectively, potentially breaching the principle of natural justice. He break the law. Inaccurate or contrary evidence. Misrepresentation. If the chairman provide inaccurate or contrary evidence, this could amount to misrepresentation of facts. So let's go again. I have 1 minute. Bias or prejudice is if the inaccuracies or contradictions suggest that the prejudice of the part of the chairman, it could be grounds of recusal. Potential legal action. If these issues are substantial, potential legal might include judicial review, challenge the chairman's decision on the grounds of procedural impropriety, breach of natural justice, application for refusal, directly requesting the chairman's refusal based on the illegal misconduct. So this is an area where we could get rid of him. So you cannot say we have to wait on a whole year. So you got to read this here. All right, you read, and you're going to see that there are potential laws to remove